Welcome to the sixth video of a YouTube series covering the 2022 edition of A Detective's Guide to Interrogation Law. As we noted in the other videos, I'm intentionally giving away all the substantive content of the book. If you watch all 9 videos and internalize the concepts explained in those videos, you'll have expert knowledge of interrogation law without spending anything but your time. I think you will find, however, that the book, and particularly the many case examples found in the book, are a valuable supplement to your viewing of the videos. It is bargain priced and available for purchase on Amazon. If you choose not to buy the book, the free YouTube videos stand on their own and provide real value to viewers. The remaining videos are going to be fairly brief. If you have stuck it out this far, you've covered most of the book. So on to today's lesson. This is video 6, which covers ethical no-contact rules. This chapter addresses investigative techniques directed at represented defendants that trigger ethical issues for government lawyers. Ethical rules regulating contacts with represented suspects do not apply to an investigator unless the investigator is an attorney or is acting as the alter ego of a government attorney. Even if an investigator is an attorney or an alter ego, it is unlikely that the ethical rules bar standard law enforcement techniques, such as wiretaps, that take place before the Sixth Amendment right to counsel has attached. In fact, it's difficult to find any case examples of ethical violations that do not also involve Sixth Amendment violations. Even if a violation of an ethical rule is found in a case, there is no definitive case law indicating what remedy, dismissal, suspension of a bar license, a reprimand, or simply an admonition not to do it again, applies. Investigators should nevertheless be aware of the ethical rules so that they can identify settings where they have freedom of action that prosecutors do not have. Most state bar associations and courts have adopted some version of ABA Rule 4.2. It bars attorneys from communicating or causing another to communicate on the subject of the representation with a person they know to be represented by a lawyer in the matter, unless they have the prior consent of the lawyer representing such other person or are authorized by law or court order to do so. These elements are examined in the sections below. This provision of Rule 4.2 refers to circumstances where the investigator, undercover officer, or informant is acting as the alter ego of the prosecutor. An alter ego relationship occurs where the prosecutor directs the actions of the officer or informant. It clearly does not cover questioning that the prosecutor only learns about later, and probably does not cover police conduct prosecutors know about but do not order and direct. Subject of the representation is viewed broadly. Prosecutors can't rely on the Sixth Amendment offense specificity limits we discussed in the last video. Anything relevant to the subject of the representation counts, which may include unrelated crimes. Rule 4.2, by its terms, does not bar contacts authorized by law or court order. Covert contacts may involve undercover officers, cooperating informants, and wiretaps. The suspects do not know they are talking to a government officer or agent. Covert contacts that do not violate the Sixth Amendment right to counsel, that is, they are pre-charge, are, quote, authorized by law, unquote, even if the suspect has an attorney on the matter. Prosecutors may accordingly supervise investigations involving undercover officers, cooperating informants, and wiretaps without violating Rule 4.2, so long as the Sixth Amendment right to counsel is not attached. Some courts have suggested that covert operations that are accompanied by related impropriety raise due process questions. This is sometimes called the case-by-case approach, but cases actually suppressing evidence on this ground are very difficult to find. Overt contacts occur when the prosecutor or investigators directed by the prosecutors, that is, the alter ego of the prosecutors, question represented suspects or witnesses without notice to their attorneys, and the suspects know that they are talking to the government. As explained in the prior video, these contacts do not violate the Sixth Amendment if they occur before the initiation of adversary judicial proceedings, are restricted to uncharged crimes, or are preceded by a Miranda waiver. These contacts sometimes occur in circumstances where a defendant distrusts his or her attorney and wants to cut a deal without the attorney's knowledge. It may also occur where a corrupt business under investigation hires counsel for its employees, and one of those employees, who may not be criminally involved, wants to cooperate with the government. These sorts of contacts may or may not qualify as being, quote, authorized by law or court order. For that reason, if it is all practical, try to avoid situations where your prosecutor does the questioning or directs the questioning by the investigator. So, you made it to the end. Thanks for that. If you have comments about the presentation or questions about some of the points I tried to make in the video, I can be reached by email at contact@trialdex.com. This was the 6th video in a YouTube series covering the 2022 edition of A Detective's Guide to Interrogation Law. The next video covers speedy arraignments. I hope to see you there.